on this. Okay, sorry about that, Michael. I wanted to catch everything you had to say in recording.
Yeah, no
Okay.
worries. Well,
Yeah.
I initially thanked you for having me to discuss this
Yes.
important issue, and I was just discussing that I've been a family law lawyer practicing in Ontario for the past 18 years. I've also practiced in New Brunswick, and Manitoba, and Alberta, and we specialize in family law. We practice that exclusively, and I have a large high conflict parenting practice. I've dealt with severe cases of parental alienation in many cases. I also have an international abduction practice, and those two pieces at times merge. And though, which adds, when you're dealing with an abduction case that has an element of alienation, meaning the child's objecting to a return to the place of habitual residence due to alienation, meaning their objections are not their own, that sort of adds a layer of complexity to the cases that we deal with. But again, I'm very happy to be here to discuss these issues with you. You're muted now. Sorry, Monique, you're muted. We can't hear you.
Oh, so sorry. Yes. Yeah, you came like you were well spoken of in our group. And our group doesn't speak highly of lawyers, so that's a high compliment that they would, recommend you. But yeah, so I wanted to ask you if you could tell us a bit about the jurisprudence of litigating PA in Canadian family court. I mean, it seems like it's not a very successful strategy, and is it different per province, would you say?
So I'd like to start by reading you a quote from a case that I was involved in many years ago. I wasn't trial counsel on it, but it was a trial decision of a judge, Justice Ingram, who is a very senior judge. I think he was formerly sort of the head of the Office of the Children's Lawyer in practice, and he's a judge in the Central East jurisdiction in Ontario. Uh, and he starts his decision with the following. He writes, Parental alienation has all the features that make a great story: a heartbroken parent, an evil ex, and a victimized child. If real life were like Hollywood, the story would eventually end with the evil ex being punished or seeing the light and repenting, and the formerly heartbroken parent reunited with their now loving and devoted child. Unfortunately, real life is not Hollywood, and such picture perfect endings rarely occur. In this case, it is the mother who is the director and the key person to determine if there will be a happy ending or if this saga will continue for years to come to the detriment of the children. While both parties, their families, and their friends have each played a role in this ongoing battle, the mother's primary focus has been to validate her allegations of abuse, raised for the first time after being served with the application for divorce, to justify her post-separation actions as being based on the desire to protect the children. That was a quote from a family lawyer who unfortunately passed away, Michelle McKelvey, at a young age. And that sort of encapsulates what we're dealing with when we're dealing with alienation cases. These are tragic cases, and parental alienation is, as Monique knows, a form of child abuse, and they have to be treated as such. And parental alienation has been defined, and I'm sure you're aware of all the literature and the experts in the field, but in a nutshell, it's a child's resistance, strong resistance or rejection of a parent that is disproportionate to that parent's behavior and out of sync with the previous parent-child relationship. So I do litigate these cases. In my view, and I say this to my clients who are the alienating parents, that immediate effective judicial intervention is necessary in cases like this, because the longer the alienated child is held captive to the alienating parent, the more difficult it becomes to reverse the emotional and psychological damage that's caused by parental alienation. We have provincial statutes throughout Canada. Each province will have their provincial legislation. In Ontario, we have our Children's Law Reform Act. And then we have the federal statute being the Divorce Act, which was recently amended. Ontario's Children's Law Reform Act was also recently amended. But in all cases, the inquiry remains an individual one, right? We are dealing with, and the court has to consider, what is in the best interest of that particular child in that child's particular circumstances. So, as I mentioned, I've argued cases, in other provinces, in Alberta, for instance, I did have a case involving parental alienation, and the principles behind the cases are the same. In that case, we had obtained an order for reunification therapy to attempt to help reunify the children with their father, my client, who in a very severe case of alienation. And I treated that case similar to the way that I would have treated a case in Ontario. Under our amended legislation, in terms of the Divorce Act, as I said, the overarching test here is what is in the best interest of the children. And there are various factors for the court to consider when determining those best interests and how to meet and address the needs of the children. And when we're determining best interests, we have to consider the age and development of the child's needs, and importantly, each spouse's willingness to support the development and maintenance of the child's relationship with the other spouse. So that's when we're getting into cases of, and there's a spectrum, right? Cases of sort of improper gatekeeping, restrictions, marginalizing the parent to the child, to the extreme cases of not at all supporting the development of a relationship and in fact thwarting it and alienating it. I had a case at the Court of Appeal, and please email me after this. If I know I mentioned the case at the start, I didn't give you the name. I'm happy to email you the case citations.
Would you be able to put your email address in the chat, Michael?
Yeah, I will do that. And if you
some point, yeah.
Yeah, because it'll be tough for me to go through and give you all the references.
Well, I think I have your email. Can I just use the email that I have with you and then put that in the chat for you?
Yeah, that's sure.
I can do that.
Yeah, that's perfect.
Awesome.
So I had a case that went to the Ontario Court of Appeal called Judicial, and the Court of Appeal is very clear in its decision that where one parent is marginalizing the other parent, that parent should not be rewarded with an order for what we previously called sole custody, but under the amended legislation, we call sole decision-making responsibility for that child, because that order itself could be abused and could have the effect of alienating a parent from that child. So these are factors that need to be considered under the amended legislation. Under the amended legislation, we also have a more expansive, broad definition of domestic violence. And domestic violence needs to be considered in the equation in determining best interests. And I have a case that's going up to the Court of Appeal that addresses the issue of domestic violence in relation to fashioning parenting awards. But in our new expansive definition of domestic violence under our amended legislation, you'll find reference to the court considering whether there is a pattern of coercive controlling behavior in relation to a family member. In my view, I think that a coercive controlling behavior, alienation is, an extreme case of coercive controlling behavior in relation to a family member, and that's to be considered under our legislation. The law that's emerging, or the cases that are emerging from the amended legislation, also includes that disparaging a parent to a child or in the presence of a child has also been determined to be a form of domestic violence. So there's an emphasis on domestic violence, but in that piece, these are principles emerging from case law that can be utilized, in my view, in cases of parental alienation. So I think that would answer your question, Monique, about sort of how.
I think some of the concerns that I've had with some of the amended legislation is that the coercive control is put only in a lot of the people that are pushing that would be for gendered violence, and they would say that coercive control is only something done by men, and that was the purpose, is actually to not, and since a lot of our targeted parents are actually men, it actually undermines them with that false narrative, and it undermines the child abuse too, that women can be child abusers and also engage in. But yeah, all the literature, like long before someone coined the term parental alienation, like there's a close tie between domestic violence and domestic abuse and child abuse and coercive control, like the use of children as weapons and coercive control has long been documented in domestic abuse literature long before anyone coined the term PA. So this is old, like to use this weaponized child like this to hurt someone,
I think that's a really good point, and I did see your helpful article about that, and I hear you on that. But I'm seeing, in my practice, that these new provisions, these expanded definitions, I think can be used in cases of alienation as well, because there can't be any form of control that cannot be a form of control cannot be clearer in terms of parental alienation.
Yeah, and
Um,
it should be no exception for women doing it to children any more than you would not excuse a man doing it to a child, like weaponizing a child. Like there should be a
yeah.
genderless zero tolerance for this kind of child abuse.
No, I hear you, and the court's responses are strong, where there is a hint of alienation, and I know there's concerns, and we can discuss concerns about sort of judicial responses of the court system and whether or not that's the best place for these cases. But unfortunately, it's really the only case where you have a completely obstinate, resistant parent who is completely thwarting and alienating a child. You need immediate judicial intervention. But I had a
Mhm.
case years ago where I represented a cardiologist, a really famous cardiologist actually, and he when he separated from his wife, he knew he wouldn't see his kids for years. He knew that could be the impact of the separation, and that was a
Mhm.
case where we had to take immediate action because the alienation was so extreme. This was a case where the mother saw my client driving, and he had a new partner, and she had the kids in the minivan with her, and she drove into his vehicle, and she was criminally charged as a result. But if she can do that in public, think about what she's doing behind the scenes in terms of the disparaging behavior and the thwarting. And so these definitions of coercive control and judges seeing that disparaging a parent is akin to domestic violence, that's a signal that that they are responding to issues of parental alienation. And it works both ways, right? I hear what you're saying about the gendered. I hear you. I mean, domestic violence in our society is insidious. It's horrific and needs to be properly dealt with. And the Supreme Court of Canada has weighed in on that recently, and I don't minimize that at all. I have cases of true domestic violence, but I think the legislation as it's been amended is assisting in high conflict cases and cases of alienation, etc.
Okay. For the questions that we have in the chat, there'll be a Q&A at the end. We'll be able to take a couple questions. But one of the questions is a measurement to prove alienation, and that kind of dovetails into my next question about the five-factor model. That's evidence-based social science. So a lot of the social science has been done for years, like all the evidence-based, but it's not being implemented for what I believe to be political reasons. So the five-factor model and the social science that we see coming out of the Parental Alienation Study Group, which is an international academic organization. Are you aware of the five-factor model?
I did see your the
Amy
video.
Baker, yeah.
Amy
So
Baker.
yeah,
She's
yeah,
based in New
Warsaw.
Jersey.
Pardon me?
I thought she was based in New Jersey, Amy Baker, or I could be
She
wrong.
is, but she's internationally known, and actually, we have a lot of Canadians that hire her and say she's actually like with some of her social science. She's a PhD and an expert, and she's actually said that well, you can read any of her books, but she's written many academic papers, and she's one of the leading experts. And her and Warshak, he wrote Divorce Poison. They're both at the Parental Alienation Study Group, which is an academic group. But so since this academic group is depoliticized and they're all about evidence based and proper social science and research, I prefer their standards because it's depoliticized and it's basically based on evidence-based research. So what can we do, like as grassroots citizens, like what can we do to get get this, what if we have a preference for this evidence-based model, like the five-factor model, like what can we do to get this implemented, like have a clear standard for identifying abuse, because that is a clear standard. I mean, you're looking for the five factors. One of them would be clear alienating, your typical alienating behaviors in the child and also in the ex-spouse. And these are like concrete things that you can witness and document. And another factor is you can't have a previous history of abuse. So these are important, checklists that I think are actually common sense and would help people, identify, because it can be very nebulous, and there's a lot of misinformation and false accusations of parental alienation too. So I think we need a clear standard. And so something like that, a five-factor model that's based on research and evidence, like, because what we really want to do is stop the child abuse and have clear interventions and have clear standards. So yeah, what can we do to get clear standards like that implemented? It's my question.
Mhm. I mean, in Ontario, there is no set sort of five-factor model that the courts are utilizing or analyzing. But we have
Yeah, but that's problematic because it can be PA can be anything, and there's also false accusations, so there's no standard, and that's what's problematic.
well, judges may rely on expert evidence in determining whether alienation has occurred. There's a very comprehensive decision of Justice Richard Bennett, who is an excellent judge sitting in the Newmarket Court. I think it was a 200-page decision where he sets out precisely all the factors that the court's to consider when determining alienation. And you're right, some of it's subtle, some of it isn't just isn't just sort of, it doesn't hit you in the face when it happens. But just as an example, when I was dealing with an alienation case, I think in the summer, it was an abduction, started as an abduction case and became a severe case of alienation, where the mother came here with the child from Florida so the child could visit father who lived in Ontario. And then the father, after the visit, overheld the child, and the child started sending these horrific text messages to my client, and the judge right out of the gate made a finding of alienation without the need for without the benefit of expert evidence, because it was there. But in our submissions for that case, we cited clinical literature and academic research that judges have relied on in other cases to make findings with respect to alienation. And we have sort of direct alienating features and behavior, and we also have indirect features of alienation. Some of the indirect, well, first let's start with direct. Some of the direct, some parental conduct directly interferes and fosters a negative attitude in a child towards the other parent. But there's other indirect undermining of a positive relationship between the child and the rejected parent. Some of the examples that, when we're arguing these cases we put before the judge would include, when one parent fails to support access or contact with the other parent, when one parent gives tacit approval of a child's negative behavior or comments to the other parent, where the child is engaged in activities that have the effect of impeding or competing with access visits, where a parent is consistently late for access drop-offs or shows up early for pickups, when children are told it's up to them whether or not access occurs, where a child sides with one parent and that parent does not try to dissuade the child from that position, when the custodial parent expresses sadness that the child is going on an access visit, thereby placing the child in a loyalty bind or in a conflicted position just prior to the visit. So these are factors that the court, if there's evidence of this type of behavior, the court is relying on that evidence in making findings of alienation. These are difficult cases. I think I saw a question about a statute of limitations. There is no sort of statute of limitation, but the longer this goes and the older the children become, it's more difficult to assess and reverse the damage. And that's why I'm a proponent of early judicial intervention. But there is no statute of limitations. Where a child is alienated, that child's chronological age is irrelevant because their views and preferences have been tainted by the alienating parent. And I've had cases where reunification therapy, reversal of primary residence has been ordered where children are older. So in that sense, there is no statute of limitation, but it's that much more difficult, and it's imperative to marshal the proper type of evidence of both direct and indirect examples of alienation.
Okay, that's excellent. Do you have any general question or general recommendations for parents that have to self-represent? Because that's certainly an issue. Like this is expensive, and there's no right to an attorney, and a lot of parents need to self-represent. Do you have any books or suggestions or tips for parents that must self-represent?
I do, and I really feel for those parents, because I always say to clients, you would never work on your own teeth, right? You wouldn't be your own dentist. These are really complicated cases that are riddled with clinical issues where sometimes you need expert assistance. I do offer bundled services if a client can't afford to have a lawyer on the record in court. You may want to obtain some independent legal advice, sort of behind the scenes. I think self-represented parties, and it's excellent that you have this resource. The fact that you're all part of this group, I think, is the start of trying to navigate, this really serious, concerning issue, because you have people like Monique who've, you've written articles, and you've read the literature. I think you have to start with the literature. You have to read to get a real sense of what this actually is and how to combat it. You
Have
know,
you read Dr. Christine Giancarlo's book? She is a expert and a scholar from the PASG, the Parental Alienation Study Group. But I've known her for years, and we're both Calgarian. And she's an instructor or a professor at Mount Royal University here in Calgary, where I live. And so I've known her for years, and she's actually an academic supporting me behind the scenes at Parental Alienation Canada. And so she reviews everything I write, peer reviews it, and makes sure. But she's a reluctant expert, as she says. But she has a book. It's called Parentectomy, and she has a chapter in the beginning. It's called anatomy of a parentectomy, and that kind of goes over a lot of the features and helps people recognize what this is. And then the end of the book, there is what her recommendations are to fix the root of the problem is a systemic problem. And then in the inside, there is cases, the stories of people affected by this. But the mental health repercussions of this issue, obviously, when people are removed from their child, it's mentally, a lot of people can't even read that kind of book and read they get triggered. And we have people breaking down, and 75% or 8% of the suicides are men, and there's a big discrimination against fathers in family court. I've been in this issue for about 8 years, and I started PAC as a gender neutral group to get all the parents together in solidarity to make a change and educate people. But it's not just the legal problem, but it's also the mental health problem that needs to be addressed. And there's very little understanding and a lot of resistance to even acknowledge this issue by some special interest groups that profit off of these false narratives, right? Especially targeting of fathers. And people don't realize the impact to the mental health. But that can be a barrier too, like for self-representing. People get financially and emotionally destroyed by this. And so, even reading the books like are triggering, and we just do the best we can trying to support people. We do have a 12-step program that we recommend that's free. And so, yeah, we have some resources, and I've done a lot of research trying to, inform people. I can show you our introductory orientation video. It's got a list of all the resources I found. But that's part of it. I just wanted to mention that to you, that people can't even get through her book. Like they can't even read all the stories in the inside of the book of people driven to suicide and railroaded by this. So reading it, trying to represent yourself and then dealing with the mental health problem. We do offer peer support at our group, and we are working our way understanding this problem. And her book does have some solutions, but and we have some resources to help people represent too. But
I'm seeing, these are tragic cases, and I'm seeing, like, from the questions that, that people are going through really, really difficult times. The older the children get, I mean, once a child reaches 18, the court no longer has jurisdiction over that child in terms of parenting issues. So, is there hope for a 25-year-old damaged by parental alienation? I mean, I've seen in these cases, like I've had cases where custody has been reversed, and children have undergone the workshop, and there's been success stories. I've also had cases where a parent has had to make the really difficult decision to take a back seat, to step back, to write sort of the goodbye letter, and then to hope. And there are cases where 10 years down the road, the alienated child reaches out to the targeted parent, and eventually it's the alienated parent who no longer has a relationship with that child. So there's always
about approach and withdraw. What we teach something called approach and withdraw. That's from the Eeny Meeny My Society. So we teach our parents to always appear stable to their alienated parent. Like you want to always shine a light into that child's world because they are being abused and gaslit, and they will have their reactivity. And that has helped Amanda gain the relationship back with her child. You shine the light into the child's world, And then they will respond with negativity, and they will react because they've been programmed. But at that point, the targeted parent needs to practice self-care. And so we have programs that we recommend, like the 12-step program, where you can get peer support, but you don't want to respond to the reactivity from the child. Like, you want to always be shining that light. So that's one way we've been coaching parents to, reconnect with their alienated child, because it's not a legal problem to reconnect with your child. It is entirely a psychological issue, right, from the gaslighting abuse. And
Mhm.
so we've self-care is like a really important value that we have in our group, the 12-step program, and focusing on the mental health component of it,
Oh,
component of it.
I think that's excellent. Those are excellent resources. The benefit of time and engaging in that type of behavior, I think, is definitely the right approach. I just had a case settle where we removed the court's jurisdiction, where my client hadn't seen or spoken with the children since 2018, and they're teenagers now. And the final settlement was release the children from, 16 and 17, release the children from the jurisdiction now. And then my client was provided with their contact information. I just received an email today that they've been speaking ever since the final order was made. And it's baby steps. So there's always hope. And I think that would be my message to some of your listeners, and
Yeah, and practice self-care in the meantime.
yeah.
Self-care is very important. For this latest question, I see a lady. I've done a lot of interviews, and we actually have a Parental Alienation Canada YouTube. I'm just going to post a video I've done with the kids books authors. We have a couple kids books author. One of them is Our Family Broke. And so there's a couple child appropriate books that we have to explain PA to children. And so I'm just going to post that link in the group.
But just back to your question about how to support self-represented parties in the litigation in the court system.
Yes.
When I'm representing alienated parents, I often seek orders for reunification therapy, orders mandating the alienating parent to get the children to, first to appoint the correct professional, right? There are really good professionals out there. Some not, it's not, some, you need someone who specializes in parental alienation to conduct this therapeutic interventions or reunification therapy, whatever you call it. I mean, it's about building, reestablishing and also supporting and building the relationship between the alienated child and their parent. And, these things can be expensive. See that, which is the concern where we have a self-represented litigant. But there is the Office of the Children's Lawyer, which in Ontario, I think it's called something else in Alberta, but this is a free service where the judge can ask the OCL, the Office of Children's Lawyer, to be appointed to represent the children. And sometimes I argue that, if the child's views and preferences are tainted, we know sort of what those views will be. But that is a concern. But the children being represented and having an advocate in cases of alienation is a strategy that sometimes works. And it would be something that would be, there's no charge to it. So a self-represented party may want to seek an order for the appointment or the request to have the OCL appointed to represent and advocate for the children, because the OCL will not just be a mouthpiece for the children, right? It may be difficult to determine whether or not the children are expressing informed views or just parenting what the alienated parent has said, but a professional will see through it and will make recommendations to the court and report to the court. You definitely need court orders that have teeth. Court orders, are not suggestions; they're mandatory. So if you have an order, like the order with the cardiologist, where I had an order for reunification therapy that then is breached, then in Ontario you have remedies under our Ontario family law rules, and this is similar in Alberta, where you can bring a contempt motion, although the Court of Appeal is sort of made clear this is a last resort. But in under our family law rules, you don't have to seek a finding of contempt. You can seek a finding of a breach of an order, and you can seek sanctions for breach. And I have a case called Karam and a case called Valetis, where the alienating parent had breached orders for reunification therapy, and the judge really sent a strong message in the form of a cost order. In the cardiologist case, the mother was ordered to pay costs of $10,000 for breaching a reunification therapy order. So these are sort of what we need to be doing here is taking immediate judicial intervention, asking the judge for orders and staying on it, not being discouraged. As a self-represented party, you don't want these cases to languish, because you want to make sure that you're in sort of a case management system where you have a judge that's sort of overseeing it, where so that there's oversight, and in the event of breach, there could be consequences to the parent who's not complying.
Okay. We have another question that's sort of related to that. iPhone, do you want to come off mute? I don't know who that is. iPhone to everyone. I've recently completed stage 1 of reunification in Calgary with Dr. Michelle Susi. Do you want to come off? Do you want to come and ask your question? Come off mute and ask your question.
So the question is, my ex has declined to move on with reunification. What do I request from the courts? Well, that sounds very promising. I mean, you now have a reunification therapist who's probably well regarded in the court system. You have an order. The first stage has been completed, and now the alienating parent has declined to move on to phase 2. I mean, I have to look at what the order actually says, but if there was an order mandating both parties to take part in this therapy, and one parent has breached that order, then you can move. I think in Calgary, you'd probably bring a contempt motion. In Ontario, we'd bring a motion for breach. But I think you need to return to the judge who made, or return to the court and highlight that, and I'm not sure if the therapist has given you a letter or would swear an affidavit, but it sounds like you could bring the matter back to court and ask for direction and sanctions for the breach of the order, the contempt of the order.
Okay. Amber, you're next. Do you want to ask a question? We are from Ontario, spent over $40,000 on a court order. Okay, do you want to come off mute and ask your question?
Sure. Yeah. So we're kind of stuck in this process of we got a court order. It was followed for a little bit and hasn't been followed at all in almost a year. We went to file a contempt motion through a lawyer, but we were advised that it's a really high threshold to prove contempt. So we're kind of just stuck in that stage of like not knowing what the next step is. And when I say not a single thing is followed, not one thing.
And when was the last time you saw your child?
It'll be a year actually this May. So right now.
Mm-hmm. So, I don't think you need to bring a contempt motion. Your lawyer is right that there is a high standard. It's quasi-criminal in nature, and you've got to have the judge make a finding of contempt first, and then you go to the sentencing phase. But in Ontario, we have the family law rules. We have Rule 1 sub 8 that says where there is non-compliance with an order, the court can impose sanctions, including monetary sanctions. I mean, I've had makeup time ordered under Rule 1.8. I've had a reattendance to reunification therapy by the parent who had breached the order. There's wide discretion by the court.
Okay.
My concern with your case is that it's languishing, right? It's now been a year, and that's totally unacceptable. You haven't seen your child in a year. That you probably want to bring. Which jurisdiction are you in? Which court?
What? It would be
Alberta, I think.
No, we're from Ontario, like right outside of Ottawa.
Oh, okay. So there are very good judges in Ottawa who, and I think if you show the court that there was a breach of an order, you should bring a motion under Rule 1.8.
Rule 1.8, okay.
Compliance and sanctions.
Yeah.
In some cases, where there has been a finding of alienation, I've had judges refer the matter to the Children's Aid Society.
Well, we actually had the OCL appointed at the very, very beginning. I'm just speaking on behalf of my fiance because he's actually supposed to be on the call, but he had to work overtime. But OCL was appointed. Everything, it's not that everything seemed to be good, but it was the wording that was used. They didn't say parental alienation, but it was like they are influenced. That was mentioned a lot. So when things were seeming to kind of settle down, that's when the false criminal allegations all of a sudden appeared. And that was during COVID. So everything just got extended over like time because of COVID and stuff. And then we finally had to settle because he just wanted to see his kids. So we settled to have this court order, and then it was being followed for about 2 months. And then all of a sudden nothing. And when I say like financial strain, like we couldn't really just go right back into court because we had just had to sell our house and like restart. So we just got the funds now to go back to court. But yeah, it's been Very, very sad. The two older kids, like you guys were saying, like it's a lot of very, very vile messages from the older kids. So we were just advised to kind of try to save like the younger kids because there's 4. So do you think that we should still try to mention the teenagers, or is that too hard because of their age?
Well, it's once you sort of normalize the parenting time with the younger ones, and the
Yeah.
teenagers see that that's happening, that may help, right?
Okay.
That may assist. Teenagers, it's dicey with teenagers, right?
Yeah.
But there are cases out there. There's a famous case called Reeves and Reeves of Justice Mossop, who's an excellent senior family law judge, where she reversed custody of a 16-year-old child who had been alienated. So
Okay.
it really depends on the evidence. It depends on what the the OCL is saying. It depends on, I think you should take advice from the child care professionals in that respect. They may say start sending birthday cards and gifts and see if they come back. Or, you may want to return to court and obtain an order. The issue of the criminal charges, I mean, that's another layer of complexity, right? Where a parent is, I'm not sure what the nature of the charges were, if it was alleged assault on the former spouse or alleged child abuse. So, the legislation, in the amended legislation, the court has to consider whether or not, first they're just charges, right? Always there's parallel proceedings. So, you don't want, and in your case, it sounds like the alienator has sort of tried to leverage the criminal or using the criminal proceeding to bolster her claims in the family court proceeding, and judges really are
and that's why he took the settlement, and then he was fully exonerated. But like I said, he had to wait a year for that criminal court case to even get through the courts. Yeah. So that's why we just chose to do the settlement, because of the pending charges. And it was, domestic violence, but it was proven false. So
that's good. So in terms of teenagers, I mean, in Canada now, or at least in Ontario, there's a big push to have the child's voice before the court, to have their views and preferences heard. Because we're a signatory to the UN Convention on the Rights of the Child, and under Section 64 of our legislation, every child has a right to be heard in any proceeding affecting them. So it's a bit complicated when we're dealing with an alienated child, because we have to be assured that their voice is really their voice, and obviously it's not their voice in a case of alienation. But there are judges who would order judicial interviews. I've had cases go to trial, and at the end of the trial, where a finding of alienation has been made, a judge would ask the children to come into chambers, and the decision would be read directly to the children, because as we all know, that child's likely been fed a false narrative in terms of what happened with the memories are not the real memories of what occurred during that relationship between the child and that parent. And in my cardiologist case, those children, we discovered after the fact, have been told that their father had never paid support, that they were starving because their father had never paid support. But in reality, this individual was paying for everything, thousands and thousands of dollars. So it's like trying to deprogram, and we all know about the workshops, etc. But judges have a role in that. And I've had judges want to speak directly to the children, to advise the children directly or through the Office of Children's Lawyer of their results and why the decision was made, just to filter out the tainted or the one-sided viewpoint of the alienating parent that isn't reality.
Michael, can we move on to the next question?
Okay, thank you.
Yeah. I'm just going to ask Bradley. Bradley, do you want to come and ask your question? Bradley.
Oh, it's about that's actually an excellent question from Bradley about, how do we know, because there is no sort of set qualifications for reunification therapists. So I think you have to take advice from your advisors. I have many professionals who are excellent on my roster of people I refer, who are really excellent reunification therapists. But you do need to obtain proper advice within the jurisdiction that you're in. But people like Andrea Barkley or Anyway, there's many therapists out there who do this work, but yeah, you have to be vigilant in who you propose, because not everybody can do this work.
Okay, next question is from Mary Anderson. I don't know if she wants to come off mute and ask her question. Mary, are you there?
Can I go back and sue? The question is, I had an OCL appointed in my case because of accusations of parental alienation. I lost my case at trial because I was a self-rep. Can I go back and sue? So it's interesting. Like, I wrote a paper years ago, 2009, about tort damages. I mean, the interplay between family law and tort, civil torts. And we made an argument that alienation should be its own tort. You should be able to sue as a result of it. I mean, there hasn't been there is no tort, right? You can't sue after the fact per se, but it's such a serious issue that, when we're dealing with damages, and there's a damages case going up to has been argued at the Court of Appeal in relation to damages for assaultive behavior, but really it's the judge created a new tort in relation to family violence. So we may be getting to a place where we're arguing that there should be a tort, tort meaning you could sue civilly for damages as a result of alienation, as a result of the loss of the connection between you and your child. It's a emerging area. There's evidentiary issues, et cetera. How do you quantify the damages, et cetera? But it's a good question, and there may be something on the horizon.
I wanted to ask a question about equal shared parenting. So Dr. Amy Baker has said that we could mitigate mild to moderate cases of PA by having, and a lot of the expenses of high conflict divorce, we have more of a model like Sweden, where you have an equal shared parenting and there's no lawyers involved, you just share the parenting. And Christine's book at the end, when she's making a recommendation, she has suggestions on how to have fair like spousal support, and you'd have to read that for the nuances of it. But essentially the basis of the law would be equal to what is actually in the Federal Divorce Act right now, where it says that child should be spending as much time with both parents as possible after divorce and maintaining the connection, because that actually is in the Divorce Act right now. But so that would mean that only in cases where you could prove child abuse, and if we have like a clear standard, like a 5-factor model. So do you have any comments to make about shared parenting?
So that is
some states are going to that, and it's actually reducing their domestic violence rates. Actually, like in Kentucky, it reduced about 18%. Their domestic violence rates reduced. So it's showing good results, and all the evidence-based research shows that when children have access to both parents and maintain all their connections with their grandparents, etc., they perform better on every metric, like their psychology, their mental health, their school, their sports, when they're buffered as much from the conflict as possible, and then you're also not destroying a family financially and only spending your resources on real child abuse. It essentially is what the spirit of that would be. So do you have any comments on that?
I think it's an excellent question, and there has been a push, by many in family law circles for legislative change, right? For a default in favor of joint decision making, what we previously called under the old law legislation joint custody, and a push for 50-50 shared parenting as the default. Similar to countries like Sweden, I think Germany has a default to joint custody as well. That is not our system, however, and the Supreme Court of Canada, in a case called Berenjet, has made it even clearer. And I know we're talking about legislative change, but every day in my practice, I'm working within the system that we have, and in the system, there's no presumptions, right? There's no presumptions in favor of either a parent in family law. There's no presumption in favor of the so-called custodial parent.
There seems to be a presumption that women will get custody. There seems to be that presumption, maybe not formally, but that's what it seems like.
I have, over the years seen that there has been sort of a pendulum shift. There's been more of a movement towards shared parenting, especially in the Toronto court, because the literature is clear that children benefit from having a relationship with both parents. And and the test, although there's no default, that the parent who's attempting to restrict time has to show that there's a risk of harm effectively. If both parents are actively involved and were equal co-parents and that was the true status quo during the relationship, then there's no reason why there should not be shared parenting. But the question is, Monique raises, is what about, people who abuse the system, right, to make false claims, like in Amber's case, false claims of domestic violence to bolster their position. I mean, and that's why courts have to be vigilant. And I go back to sort of, how do we deal with these cases? These are individualized. It's a case by case basis, right? This is all about what's in the best interest of your particular child in the particular set of circumstances in which you face. And in the maximum contact principle, my case I mentioned, the Regillo case, made clear that courts must adhere to the maximum contact principle. The law, though, that was in 2019. The amended legislation has removed the words maximum contact because some were perceiving maximum contact to be akin to equal parenting, which it wasn't. But Monique is right that the amended legislation says that children should have as much time as possible with both parents, consistent with their best interests. Right, everything is subordinated to what is in the best interest of those particular children. So the Supreme Court in this case called Berenjet has sort of recast the maximum contact principle and called it parenting time consistent with best interest of the child. It's really as opposed to a maximum contact principle, we're now pursuant to the Supreme Court of Canada case, referring to more of a parenting time factor. So, the question of, how would you feel as a lawyer only litigating child custody disputes if there's proof of child abuse? It's a good question. And my response really is that parental alienation is a form of child abuse. And I do litigate in that area. And unfortunately, for years, I've been litigating in this area. These are cases that by definition cannot be mediated because you don't have both parents acting in good faith. You have one parent who's actively thwarting and trying to eliminate the other parent from the child's life. So we do litigate these cases, which I consider a form of child abuse. And my further response is that, even notwithstanding that there's no default here, parenting cases take all forms, right? We can go from high conflict, which isn't necessarily alienation, to severe cases of abuse, to gatekeeping and
For the equal shared parenting, though, like if you have an equal shared parenting, that is different than shared parenting. Equal shared parenting means both parents have equal power in the system. So if you have equal power in the system, one parent cannot arbitrarily block the other one from picking up a child at school, or accessing medical records or booking a child appointment. That's the point. And that's why it would mitigate actually the mild to moderate cases of the parental alienation. Obviously, for the more severe cases where you're dealing with someone like a narcissist or a cluster B personality disorder, which is what we think is happening with these very severe alienation cases, because they seem to be like detached from reality, really don't care about the harm they're doing to their child. And so that would be a child abuse, and we would need interventions. And actually, all the evidence in the Warshak's paper of 10 myths show that there is no trauma inflicted on the child to remove a child from the alienator, and they will actually reattach back to the targeted parent once they're removed from the alienating parents. Like, children are very adaptive; they will certainly reattach to the targeted parent. So that's kind of like our vision: is we want both parents equally having the same power so that one cannot be undermined. If they were both fit before the divorce, then they're obviously both fit afterwards, right? The problem is, like, what a lot of these cases with the mild and moderate, it seems like the system is a litigation-based model. It's encouraging this for billable hours in a lot of ways, and that's why we would rather only spend the resources on and bankrupting families, right? So if the basis of the law is that both parents have equal, but the people that are resisting this equal shared parenting, they seem to be a shrill minority, and they actually don't represent the majority of our issues. And so we're trying to galvanize ourselves. I've been trying to galvanize us in the parental and try to have more of an organized voice about our concerns. And we do feel that a shared parenting if both parents are equal after the split, that would mitigate a lot of these mild to moderate cases immediately, and rescue a lot of people from the tremendous emotional and financial costs of our litigation-based system, which really isn't appropriate to impose on a family dynamic like a divorce. Litigation is not appropriate for how to parent a child. That's not appropriate. So yeah.
Those are all good points. I would say that there is power. That parents do have power under our existing.
Doesn't seem like it.
They're under our amended legislation, both parents have an equal right to decision making. Sorry, I shouldn't say right, but are entitled to decision-making responsibility for the children. Each parent has the right to obtain information directly from the child's educational and professional childcare professionals, etc. So one parent can't simply just go off and change a child's school.
Yes, they can. That's exactly what's going on. You know, they are able to
You have
block the other
remedies.
parent from medical records or book a medical appointment for the child or block the child block. And that's the problem is they're not having equal power. And that's what the principle of the equal shared parenting would finally fix the root of that problem where you can't have
They
a
both
narcissist do this anymore.
Yeah, but they are both equally entitled to decision making. There's a pursuant to the existing legislation. It's in the Divorce Act, in the Children's Law Reform Act. So you have remedies as a parent. If someone does that, my advice would be, my response would be to attend in court and to present the evidence that there's been a unilateral engaging in what we call self-help, improper self-help, where I've had cases where a client calls me and says, the other parent has just taken the child and just relocated the child to a different province or relocated the child to a different city, thus significantly impacting on the relationship of the left behind parent. And we rush off to court and we argue there's been improper self-help and there's been a breach of that section of the Divorce Act. And the judges have responded and had ordered children to be returned. So I hear you on the default. It hasn't happened.
There was a huge campaign in the late 1990s, very popular. Like all the polls show that the majority are supporting this idea of a shared parenting. But it seems like minority groups and the really shrill minority groups are the ones that block it every time. There's been two equal shared parenting bills, and they've both been blocked by the Canadian Bar Association and also by gendered violence, which is a multi-billion-dollar industry that is built on a narrative that only women are victims and men are always abusive, right? And to show that women are abusing children would not be very productive for that narrative, right? So that's what they're our opponents, are one of those two are our main opponents for what we're trying to do here. But I certainly don't think child abuse is gendered, and I'm very outspoken about stopping all forms of child abuse, including parental alienation, which I believe to be the most common form of child abuse in Canada right now. Yeah, we were so happy to see you today. I hope you will come back and speak to us again anytime.
My
You're
pleasure.
you're welcome anytime with our group, and I will send you some of our videos and resources. I'll be posting this on our YouTube video, and I'll be sending it to you. But I hope you'll come and speak to us again, and you're always welcome in our group. We're very happy to speak.
Thank you, Monique. Thank you for inviting me, and I thought this was very helpful, and I wish all the members here, if you're going through this, I wish you all the best, and keep pushing, be vigilant. Judges do respond, and the worst thing you can do is to give up. And Justice Harper, a great judge in Hamilton, I think he's retired now, said the court will not give up on children in a big alienation case. And
okay.
And I will, please email me. I'll send you out the names of the cases, etc. I hope I've addressed many of the questions in here. But
I think we'll have some more, but we'd love to have you back another time, chat again for maybe another hour if you have time. Maybe anytime you're welcome back with us, obviously.
My pleasure.
Happy to speak with you.
Yeah. Thanks, Monique. Thanks, everybody.
Take care. Thank you.
Take care. All the best.
Bye now.